This joint assembly is convened pursuant to the provisions of JRS 18, which the clerk will now read.
JRS 18, joint resolution providing for a joint assembly to vote on the retention of 2 superior judges and 3 magistrates. Whereas declarations have been submitted by the following 2 superior judges that they be retained for another 6-year term, Judge Brian J. Grierson and Judge Nancy J. Waples, and 3 magistrates that they be retained for another 6-year term. Magistrate Christine A. Hoyt, Magistrate Joseph M. Lorman, and Magistrate Brian Valentine. And whereas the procedures of the Joint Assembly on judicial retention require at least 1 public hearing and the review of information provided by each candidate and the comments of members of the Vermont Bar and the public, and whereas the committee was unable to fulfill its responsibilities under subsection 608, capital B, of Title IV to evaluate the judicial performance of the candidates seeking to be retained in office by March 11, 2021, the date specified in subsection 608E of Title IV, and for a vote in the Joint Assembly to be held on March 18, 2021, the date specified in subsection 10B of Title II, and whereas subsection 608G of Title IV permits the General Assembly to defer action on the retention of judges to a subsequent Joint Assembly when the committee is not able to make a timely recommendation, and whereas Vermont has been declared by the governor to be in a state of emergency as a result of a pandemic known as COVID-19, and whereas it is critical to take steps to control outbreaks of COVID-19 to minimize the risk to the public, maintain the health and safety of Vermonters, and limit the spread of infection in our community, and whereas technology exists which would enable the General Assembly to conduct a joint assembly during this time of a declared emergency in a manner consistent with public access to and transparency of its proceedings as demanded by the Vermont Constitution, and consistent with and in compliance with statutory and legislative rule requirements regarding judicial retention. Now, therefore, be it resolved by the Senate and House of Representatives that the 2 houses meet in joint assembly on Thursday, March 25, 2021 at 10:30 in the forenoon to vote on the retention of 2 superior judges and 3 magistrates. And be it further resolved that the joint assembly shall be conducted concurrently electronically, at which members of the General Assembly may participate and debate from a remote location. That voting by ballot shall be conducted as practicable, consistent with Vermont's early or absentee voters statute at 17 VSA section 2531 et sec. That after the reports of the Committee on Judicial Retention, the Joint Assembly shall recess until Thursday, April 1, 2021 at 2 p.m. or as otherwise ordered by the Joint Assembly, so that the ballots may be submitted, and that upon reconvening, the results of the vote shall be announced, or the Joint Assembly shall proceed until the above is completed.
Pursuant to our Constitution and statutes, we are assembled here today in joint assembly to cast our votes on the retention of 2 superior judges and 3 magistrates. We are operating under the Judicial Retention Act passed in 1976, as amended in subsequent sessions of the General Assembly, which establishes the procedure for the retention of incumbent superior judges and incumbent magistrates. There will be 2 separate ballots, one containing the names of all the judges of the Superior Court and one containing the names of the magistrates. Amendments made in 2010 require the retention of magistrates. The procedure to be followed requires that the vote be by written ballot. I will explain later the written ballots and submitting your votes. We now proceed to the matter of retention of the superior judges. Under the Judicial Retention Act, which establishes the procedure for the retention of these judges, nominations may not be received from the floor. Rather, each judge seeking retention must file a declaration of intention to seek retention with the Secretary of State. Or, if a judge is appointed after September 1 of the year preceding the expiration of the term of office, the judge shall automatically be a candidate for retention without filing notice. By this means, the name of each judge seeking retention is automatically placed in nomination and considered for retention pursuant to the terms of the Judicial Retention Act. In addition, the Judicial Retention Act provides that when a candidate does so declare for retention, the question to be decided shall automatically be, shall the following superior judges be retained in office? The statute provides the vote on the question shall be by one written ballot containing the name of all of the superior judges. Accordingly, we will need tellers. The chair now appoints the following tellers. Senator Ballin of Windham as chief teller, Senator Perchlik of Washington, Representative Kitzmiller of Montpelier, Representative Goslin of Northfield. We shall now proceed to the matter of retention of the incumbent superior judges. For this position, we have received 2 declarations of intention to seek retention to the office of superior judge from the following: Brian J. Grierson and Nancy J. Waples. The question to be decided in this case is, shall Superior Judge Brian J. Grierson be retained in office? Yes or no? Shall Superior Judge Nancy J. Waples be retained in office? Yes or no? The ballot which you will receive will contain this question in printed form on one single ballot. The term of these judges are for 6 years from and including the first day of April 2021 and until his or her successor is elected and qualified. After presentation of the report, the question will be open for general debate. To facilitate the procedure for this morning, the chair will rule, unless there is an objection, that the debate on these judges be received separately. At the end of the debate for the 2 judges, any general debate on the entire question shall be in order. First, we'll receive the report of the Joint Committee on Judicial Retention. The chair now recognizes the chair of this committee, the member from Stannard, Representative Troiano, for the purposes of receiving the report. Representative, I'm going to kindly ask you to unmute and start from the beginning. Thank you.
Very sorry. Madam President, members of the General Assembly, when our governor appoints our judges to the bench, they must appear before the Joint Committee for Judicial Retention every 6 years. If a judge is appointed to a position which is up for retention in 3 years, this review follows the position and not the judge, and therefore they are reviewed after 3 years on the bench. This is why the committee saw Magistrate Lorman after he has been on the bench for only 3 years. As you've already heard in the resolutions, the Joint Retention Committee today presents to you and the Assembly information concerning our 2 Superior Court judges and 3 magistrates. Superior Court Judge Brian Grierson, Superior Court Judge Nancy Waples, Magistrates Lorman, Christine Hoyt, and Brian Valentine are all seeking to be retained for another 6 years in office. The Retention Committee, consisting of 8 members, 4 from the House and 4 from the Senate, was charged with evaluating judicial performance, including, but not limited to, such factors as integrity, judicial temperament, impartiality, health, diligence, legal knowledge, and administrative skills. The judges and magistrates submitted information about their education, previous employment, finances, and copies of some of their judicial decisions and expressions as to why they wish to be retained. They answered questions and participated in interviews with the committee and were the subject of a public hearing about their performance on the job. Staff members employed in the courts were surveyed, as were attorneys who appear before the judges, guardians ad litem, and probation and parole officers, and others. Litigants who appear before the court weighed in as well. And naturally, some were satisfied and some were dissatisfied. Given the nature of this business, information received needed to be weighed in that light. All responses are filed anonymously unless a party chooses to provide his or her name. Vermont chooses to evaluate their Supreme Court justices, Superior Court judges, and now magistrates via the retention process versus having them campaign for election by the public for every 6 years, which happens in some states. Election by the general public in Vermont is the method for selecting only probate judges and assistant judges, formerly known as side judges. Your retention committee was very conscientious in their work, and I thank them for their diligence. The committee thanks Eric Fitzpatrick from Legislative Counsel and Peggy Delaney, committee assistants, for their work on this judicial retention, which was completed via Zoom this year. Madam President, that concludes my report.
Thank you. The chair now recognizes the member from Burlington, Representative Colburn, for the report on Superior Court Judge Grierson.
Madam President, Brian J. Grierson occupies the position of Chief Superior Judge, formerly known as Administrative Judge. Judge Grierson is a graduate of the University of Vermont and Suffolk University Law School, where he obtained his Juris Doctorate degree. In his long legal career, he has served as a deputy state's attorney in the Washington County State's Attorney's Office and an attorney in private practice for decades. In 2004, he was appointed as a judge, and in 2015, he was appointed to the role of Chief Superior Judge. This role is a unique one. He advises the legislature on the potential impacts that our proposals may have on the judiciary, helps us to understand how judges will interpret legislation, and keeps us apprised of how bills that become law are playing out in Vermont courts. Many of you will know him from his appearances in your committees. The Chief Superior Judge also implements the judicial rotation schedule, coordinating which judges serve in which jurisdictions, a task which has been particularly demanding in recent years, as 15 new judges have been appointed to the bench. Judge Grierson coordinates orientation for new judges and educational opportunities for members of the judiciary and beyond. Judge Grierson continues to preside from time to time in Vermont courts, covering temporary absences when he can, to continue with some hands-on experience in courtroom settings. He has particular interest and expertise in treatment dockets, having presided over adult drug treatment and mental health dockets prior to becoming Chief Superior Judge. In more recent years, he has temporarily presided over adult criminal drug treatment dockets in Chittenden, Rutland, and Windsor counties, over the mental health treatment docket in Chittenden, and over a DUI docket in Windsor County. His commitment to treatment courts persists in other forms as well. He was appointed to the board of directors of the New England Drug Court Professionals, received the first Matthew Katz Award in recognition of his work on treatment courts, and was a 2019 recipient of a Washington County Mental Health Community Services Award for the same. He has also served on a group to reform the Children in Need of Care or Supervision, or CHINS docket, and successfully recommended the pilot of a judicial master position in Chittenden and Franklin counties to help address backlogs in these proceedings. He serves on the Judicial Education Committee, all 4 division oversight committees, the Judicial Ethics Committee, and a number of committees and working groups formed by the legislature, including the Sentencing Commission, the Racial Disparities in Criminal and Juvenile Justice Advisory Panel, and the Committee on Non-Hospitalization Orders. Although Judge Grierson received high marks on survey evaluations and was unanimously recommended for retention by respondents, your Judicial Retention Committee does note that new feedback methods and criteria would better serve our ability to evaluate the unique position of Chief Superior Judge moving forward. And we commit to working collaboratively with stakeholders to help move this forward. Concerns also came up in our discussions about the need to resume jury trials, which have been on hold during the COVID emergency, and to deliver speedy access to justice for Vermonters. The committee appreciates Judge Grierson's efforts to troubleshoot resumption of these trials over the last year, and notes that all parties in the system have recognized the challenges presented by our current circumstances. Thus, these concerns are not a reflection on Judge Grierson, but important to note as a priority moving forward. Madam President, your Judicial Retention Committee fully supported the retention of Judge Grierson for additional 6-year term on a vote of 8-0-0, and we ask members of this body to do the same. That concludes my report.
Thank you. Accordingly, we will now proceed to any debate on the first Superior Judge up for retention, Superior Judge Brian J. Grierson. Members of the Joint Assembly are kindly asked to use the Zoom hand function if you would like to be recognized. The chair now recognizes the senator from Windsor, Senator Nitka, who will give the report on Superior Court Judge Waples.
I am reporting about Judge Nancy Waples, who is seeking a second term as a Superior Court judge. She was appointed to the bench in 2015 by then Governor Peter Shumlin. At the time of her swearing in, she received this advice from her mother: "You work for the people, don't let them down." Judge Waples started her career in New York City as an assistant district attorney following her graduation from St. John's University School of Law. She subsequently had a solo practice providing legal services, mostly for free, to non-English speaking Asians whom she met through her parents' Chinese restaurant. She herself knew many of them as she had worked there many years while growing up. In 1991, Judge Waples relocated to Vermont. In 1998, she joined the legal firm of Murdoch and Hughes in Burlington and worked as a criminal defense attorney. From there, she took a position as an assistant U.S. attorney in Rutland, working as a federal prosecutor in the southern part of the state. Cases involved drug-related offenses, bank robberies, firearms offenses, fraud, and other federal crimes. From 2008 to 2013, she was employed by the Hoff Curtis law firm in Burlington, where she had a diverse caseload. At the time she was appointed to the bench, she had practiced law for 27 years. Presently, Judge Waples is presiding in the Lamoille County Courts, where the judge assigned there handles all dockets: criminal, juvenile, family, and civil. The probate court, which is separate, has its own elected judge. Judge Waples reported that it definitely is a challenge during the pandemic, and at the same time dealing with the court's new electronic management system. But even more so, most challenging is deciding cases in which one or more parties are pro se. She is committed to making sure parties are heard, have been treated fairly and have equal access to justice. Judge Waples has also presided in the interpreter block in Chittenden County. Working with the Bar Association, she created the diversity section. She is currently serving on the governor's Racial Equity Advisory Panel, as well as on the Judiciary's Language Access for the Courts Committee. Judge Waples is an English as a second language speaker herself, and reports she did not become proficient in English until she was age 9. She also mentioned that her first appearance in court was when she became a United States citizen, one of the proudest moments of her life. She has since spent a lot of time in court, where she has had much success serving the Vermont judiciary. Judge Waples continues to take seminars and continuing education courses. Judge Waples is well respected and received very positive responses on the surveys about her work. One would say she's a rock star. A grave concern of hers is the opioid epidemic and the ravaging effects it is having on our state. Judge Waples And, excuse me, Judge Waples says she sees all the effects of opioids in the court on a very regular basis. Judge Waples is married and has 2 sons. She enjoys golf, opera, and gardening. She also doesn't mind driving around Vermont with doing all the traveling that Vermont judges have to do. She thinks Vermont is the most beautiful state in the country. The vote recommending retention for Judge Waples for 6 more years was 8 in favor and none opposed. We hope you will support our recommendation. Madam President, that completes my report.
Thank you, Senator. We will now proceed to any debate on the second Superior Judge up for retention, Superior Judge Nancy J. Waples. Again, members of the General Assembly are kindly asked to raise your Zoom hand to be recognized. We shall now proceed to the matter of the retention of 3 magistrates. Again, nominations are not received from the floor. Rather, each magistrate who seeks retention files a declaration of intention to stand for retention with the Secretary of State. Or, if a magistrate is appointed after September 1 of the year preceding the expiration of the term of office, shall automatically be a candidate for retention without filing notice. By this means, the name of each magistrate is automatically placed in nomination and considered for retention. In addition, the Judicial Retention Act provides that when a candidate does so declare for retention, this question shall be decided automatically. The question shall be, shall the following magistrates be retained in office? The statute provides the vote on the question shall be by 1 written ballot containing the names of all of the magistrates. With respect to the retention of the incumbent magistrates, 3 declarations were received and are as follows. Christine A. Hoyt, Joseph M. Lorman, Brian Valentine. The question to be decided shall be as follows. Shall Magistrate Christine A. Hoyt be retained in office? Yes or no? Shall Magistrate Joseph M. Lorman be retained in office? Yes or no? Shall Magistrate Brian Valentine be retained in office? Yes or no? The ballot which you will receive will contain this question in printed form on 1 single ballot. The term of the magistrates is for 6 years from and including the first day of April 2021 and until a successor is appointed and qualified. After the presentation of the reports, the question will be opened for general debate. The chair now recognizes the senator from Addison, Senator Hardy, for the purpose of receiving the report on Magistrate Hoyt.
Thank you, Madam President. It is my pleasure to report the findings and recommendation of the Judicial Retention Committee regarding Magistrate Christine Hoyt. Magistrate Hoyt is a resident of Tunbridge and serves as one of 5 Superior Court magistrates in Vermont, currently assigned to the Windham and Windsor units of the Family Division of the Vermont Superior Court. Magistrate Hoyt has served the judiciary since 1994, when she was hired as a case manager for the Windsor Family Court. In 1998, she was appointed as a magistrate in the Windsor and Windham Family Court divisions and has served there for the past 23 years. She is a graduate of the University of Vermont and Vermont Law School and was admitted to the Vermont Bar in 1986. Prior to her appointment to the judiciary, Magistrate Hoyt was a private practice lawyer in Bethel, where she practiced family law and real estate law. Magistrate Hoyt regularly participates in professional development opportunities, including as a presenter or panelist. She notes that, quote, teaching others provides an opportunity to look in depth at certain aspects of the law that she deals with daily and allows her to consider new and different opinions and interpretations of the law, unquote. This past year, access to professional development and opportunities has actually been enhanced due to the newly available remote programs, and Magistrate Hoyt attended 15 such courses between April and November 2020. As a member of the Judicial Education Committee, she has also been instrumental in providing robust remote educational opportunities to judges throughout Vermont during the pandemic. In addition, Magistrate Hoyt has helped create a training manual for magistrates and regularly acts as a mentor for new magistrates. Indeed, Magistrate Hoyt has agreed to assist as a mentor and counselor in the remediation plan of Magistrate Lorman, who is also up for retention vote today. Her years of experience, deep knowledge of family law and dynamics, empathetic nature, and positive outlook make her an outstanding mentor. Magistrate Hoyt reports that the combination of the pandemic and the rollout of the Odyssey Next Generation Case Management Project have presented significant challenges over the past year. A bright spot has been the ability for increased communication among judicial staff, mitigating the general loneliness of being a judicial officer and better enabling shared resources and knowledge. In addition, technology has allowed better access to the judicial process for many participants in family court, although technology and connectivity challenges persist. Magistrate Hoyt's attention to process in the courtroom, which she describes as, quote, providing a roadmap on how things are going to work, include explaining who is going to speak when and the implications of her decisions for all parties involved. The written cases that Magistrate Hoyt submitted for review were clear and well-reasoned. Among participants in the performance surveys, nearly every respondent sung the praises of Magistrate Hoyt, with comments such as, Magistrate Hoyt is the paragon of excellent judicial officer, and she is one of the most prepared and even-keeled judges on the bench, and Magistrate Hoyt is one of the finest jurists in Vermont, and she has a temperament that puts all at ease. I could go on with these glowing comments, but I'm certain you understand that Magistrate Hoyt is extremely well respected by staff and attorneys among whom she works regularly. 100% of them recommended that she be retained. Magistrate Hoyt's positive, knowledgeable demeanor is both calming and exciting. Calming for people with difficult problems who appear before her in court, and exciting for those of us reviewing judicial officers. That someone of the caliber of Magistrate Hoyt is helping Vermont families resolve conflicts and move on positively with their lives ensures trust and confidence in the Vermont Family Court. Your Judicial Retention Committee voted 8-0-0 to recommend retaining Magistrate Christine Hoyt, and we ask that you concur. Thank you, Madam President.
Thank you, Senator. We will now proceed to any debate on the magistrate up for retention. Magistrate Christine A. Hoyt. The chair now recognizes the representative from Rutland City, Representative Knott, for the purpose of receiving the report on Magistrate Joseph M. Lorman.
Thank you, Madam Chair, President. Magistrate Joseph Lorman has served as a Superior Court magistrate for 3 years. Magistrates primarily hear child support cases and can also hear parentage, temporary parental rights and responsibilities, and parent-child contact, and temporary spousal maintenance cases. He hears cases in Rutland, Bennington, and Addison counties. Before becoming a magistrate, he spent approximately 12 years in legal practice. The last 8 of those years, he was an attorney at the Vermont Office of Child Support. During this time, he became versed in child support and family law. He was born and currently lives in Rutland. He attended Boston College and Albany Law School. Magistrate Lorman is seeking retention because he believes being a magistrate is the best job he has ever had and believes it is an honor and a privilege to serve the people of Vermont. In self-reflection, Magistrate Lorman recognized he has room for improvement. He especially cited his difficulty finding time to write decisions. He has hearings scheduled 5 days a week in 3 different counties, with just 1 day per month set aside to write decisions. Magistrate Lorman acknowledged this was an area he needed improvement and has already begun efforts during his regular daily process to make time for writing decisions. The sample decisions Magistrate Lorman submitted for review were thoroughly written and his decisions clearly spelled out. These were all child support cases, and while most likely the losing party was disappointed with the decision, they were written in a building, explanatory manner that laid the deliberation process bare and easy to comprehend. What did give the committee concern, however, were the staff reviews for Judge Lorman. Staff comments included concerns that Magistrate Lorman was often late to come to the bench and that he gives the appearance of avoiding hearing contested cases. Staff who responded to the survey were evenly split on whether or not they believed Magistrate Lorman should be reappointed. These were not concerns the committee took lightly, and the committee spent significant time discussing them with Magistrate Lorman. The committee did note that he has only served as a magistrate for 3 years, one of them under COVID restrictions, and that the number of staff who took the survey was fairly small. But while those factors were considered, the committee felt that significant action needed to be taken by Magistrate Lorman if we were to move forward a recommendation of retention. During our discussions of these concerns, Magistrate Lorman appeared contrite and humbled. He was willing to take the actions needed to continue serving. To this end, he worked with Chief Superior Judge Brian Grierson to draft a plan to address the concerns raised in the staff reviews and to strengthen his performance as a magistrate overall. Both Judge Grierson and Magistrate Lorman have signed this plan. Additionally, Magistrate Christine Hoyt has agreed to mentor Magistrate Lorman. The committee felt this mentorship by a more experienced magistrate would also be a benefit and help Magistrate Lorman make the necessary improvements to his service on the bench. Given Magistrate Lorman's acknowledgement of the criticisms raised in the reviews and his actions to make measurable improvements as highlighted specifically by the action plan with Judge Grierson and the mentorship by Magistrate Hoyt, your Judicial Retention Committee unanimously felt comfortable supporting the retention of Magistrate Lorman. The committee therefore voted to recommend to the General Assembly to retain Magistrate Lorman for an additional 6-year term. This vote passed 8-0, and we ask the members of this body to do the same. Thank you. That concludes my report.
Thank you, Representative. We will now proceed to any debate on the magistrate up for retention, Magistrate Joseph M. Lorman. Is there any debate? The chair now recognizes the senator from Windsor, Senator McCormick, for the purpose of receiving the report on Magistrate Brian Valentine.
Thank you, Madam President. Madam President, Madam Speaker, and colleagues, it's my pleasure to rise in support of the retention of Superior Court Magistrate Brian Valentine. Your Judicial Retention Committee has done the due diligence as described by the chair of our committee and have concluded that Magistrate Valentine should indeed be retained. Brian Valentine is 58 years old. He earned his BA from Fordham University in 1985 and his Juris Doctorate from Fordham Law in 1989. His private practice of law spanned 25 years, focused primarily on family law, which provided him with a strong background for a magistrate's family law focus. He says he loves family law, a surprising attitude since many lawyers complain of the anger and heartbreak of such issues. But Magistrate Valentine says family law addresses, in his words, the most fundamental relationships, and so needs to be addressed with reason and sensitivity. He sees family law as an opportunity to serve, and he takes pride in a practice that helped antagonistic litigants find common ground, especially in their children, and in helping adversaries work together. Governor Shumlin appointed Brian Valentine to the office of Superior Court Magistrate in August 2015. Since 2017, he has also served as a substitute superior judge. This latter is not this position to which he seeks retention, but the committee saw it as a good measure of the confidence placed in him by our judiciary. Despite his efforts to nurture mutual respect and cooperation, he recognizes that sometimes decisions must be made and issues resolved. Quote, people need closure to get on with their lives, close quote. His goal in such cases is to be sure that even litigants who are disappointed in his decisions know, or have reason to know, that they've been treated fairly, if not as they had hoped. He tends carefully to the needs of pro se litigants. In discussing his successes, Magistrate Valentine humbly gives credit to the examples of older judges whose work he admires. He also credits his collegial relationships with other magistrates, and he speaks of his need to take care of his decision-making muscle through diet, exercise, and reflection. He is a volunteer fireman and an EMT. He says he is still learning. Magistrate Valentine's comments from lawyers and staff are good. In the interest of full disclosure, I'll mention that there were some negative comments, as there usually are. Some folks find him long-winded. I found his decisions to be densely thorough and complete. Of course, from time to time, I'm accused of being long-winded, so maybe I was more tolerant than I should have been. One lawyer says that he is biased against men, and two lawyers say he's biased against women. It can be argued that these negative comments are not numerous enough to be statistically reliable, but more to the point, they are anomalies. Brian Valentine's comments are overwhelmingly positive. On all the questions regarding temperament, integrity, competence, answers consistently range between good and excellent, leaning toward excellent. 95.24% of lawyers say he should be retained. 100% of staff say he should be retained. Your Judicial Retention Committee has voted 8-0-0 to recommend that the legislature retain Superior Court Magistrate Brian Valentine, and that completes my report.
Thank you, Senator. We'll now proceed to any debate on the magistrate up for retention, Magistrate Brian Valentine. There being no debate, are you ready for the question? And if so, I want to remind you of the rules that govern us. Pursuant to JRS 18, the vote on the retention of superior judges and magistrates shall be conducted as practicable, consistent with Vermont's early or absentee voter statute. In conformance with this requirement, ballots and related documents were sent to you last week prior to this joint assembly. In the envelope you received, you should have two ballots, a certification ballot, an addressed postage prepaid return envelope, and an instruction sheet. As explained in the instruction sheet, you are to do the following. Vote your ballots. Place your voted ballots inside the certification envelope. Print your name in the space provided on the front certification envelope and sign the certification on the certification envelope. Seal the certification envelope with your voted ballots inside. Put the certification envelope inside the prepaid, pre-addressed mailing envelope and mail back the envelope. Please return your ballots by mail or in person so it is received by noon, April 1st, 2021. Note the date for return is noon, April 1st, 2021. Are there any questions? Seeing none, hearing none, the chair now declares pursuant to JRS 18, the joint assembly shall stand in recess until Thursday, April 1st, 2021 at 2 p.m.